Hello viewers, in the continuation of our previous lecture on the cyber security, today we will discuss the Information Technology Amendment Act 2008. In the year 2000, India enacted its first law on the information technology, namely the Information Technology Act 2000. The IT Act 2000 is based on the model law of e-commerce adopted by UNICETRAL in 1996. The preamble of the IT Act 2000 points out a threefold objective. Firstly, to provide legal recognition for the transactions carried out through electronic means. Secondly, to facilitate the electronic filing of documents with the government agencies. And thirdly, to amend certain acts, inter alia the Indian Penal Code 1860, the Indian Evidence Act 1872. The IT Act gave legal validity and recognition to electronic documents and digital signatures and enabled conclusion of legally valid and enforceable e-contracts. It also provides a regulatory regime to supervise the certifying authorities issuing digital signature certificates and created civil and criminal liabilities for contraventions of the provisions of the IT Act 2000. It also conferred on the central government the power to appoint adjudicating authority to adjudge whether a person has committed a contravention within the meaning of this act and conferred on this authorities the powers vested in a civil court. With the passage of time, as technology developed further and new methods of committing crime using internet and computer surfaced, the need was felt to amend the IT Act 2000 to insert new kinds of cyber offences and plug in other loopholes that posed hurdles in the effective enforcement of the IT Act 2000. This led to the passage of the Information Technology Amendment Act 2008, which was made effective from 27th October 2009. The IT Act 2008 has brought marked changes in the IT Act 2000 on several counts. In this lecture, I intended to discuss the major changes brought about by the IT Act 2008. There are also challenges posed by the Amended Act that can be foreseen, and our country needs to be well equipped to overcome these challenges. The role of adjudicating authority in the Amended Act is very significant. The subject matter of its jurisdiction at judging matters, alleging contraventions and awarding compensation under Chapter 9 is explained in clearer terms in the Amended IT Act. The Amended Act also contains the powers and jurisdictions of the adjudicating officers and exclude those matters where compensation claimed is more than 5 crores. In this lecture, we will discuss the important dimensions that emerge from the recent amendments and challenges that will be faced by the adjudicating officers in complying with its prescribed duties under the IT Act 2008. First, we will discuss that electronic signatures introduced with the passage of the IT Amendment Act 2008. India has become technological neutral due to the adoption of electronic signature as a legally valid mode of executing signatures. This includes digital signature as one of the modes of the signature and is far borders in the ambit concerning biometrics and other new forms of creating electronic signatures. This is a positive change as India has different segment of people and all may not be technologically adapt to understand and use the digital signatures. Then forms of authentication that are simpler to use such as retina scanning can be quite useful in the effective implementation of the Act. However, the challenge it poses is accessibility to authentication tools, imparting education to the people to use the same. It is a challenging task for the central government to prescribe conditions for the considering reliability of electronic signatures or electronic authentication techniques under section 3A subclause 2. The procedure for ascertaining electronic signature or authentication under section 3A subclause 3, the manner in which information may be authenticated by the electronic signature in section 5. It also involves expenditure, as such authentication tools will require purchase, installation and training, particularly in all the government departments where it is proposed to be used. Equally challenging will be the drafting of duties of subscriber of electronic signature certificate under section 40A of the Act, which will need to incorporate security measures subscribers can adopt depending on electronic signature being used for the signature. Further, in a move to secure the flow of data and information on the internet and promote e-commerce and e-governance, the Amended Act in section 84A has empowered the central government to prescribe modes or methods for encryption. These parameters should be laid down in consultation with organizations such as NASSCOM and or governmental agencies that can assist in the formulation of necessary standards and related rules. Corporate responsibility has been introduced in section 43A. The corporate responsibility for data protection is incorporated in section 43A in the Amended IT Act 2000, whereby the corporate bodies handling sensitive personal information or data in a computer resource are under an obligation to ensure adoption of reasonable security practices to maintain its secrecy, following which they may be liable to pay damages. Also, there is no limit to the amount of compensation that may be awarded by virtue of this section. This section must be read with section 85 of the IT Act 2000, whereby all the persons responsible to the company for conduct of its business shall be held guilty in the case offences was committed by a company unless no knowledge or due diligence to prevent the contravention is proved. Insertion of this provision is particular significance to BPO companies that handles such sensitive information in the regular course of their business. This provision is important to secure sensitive data and is hence a step in a right direction. First, elucidate what we will qualify as reasonable security practice. The Act in explanation to the section 43A indicates these procedures designate to protect such information from unauthorized access, damage, use, modification, disclosure or impairment as may be specified in an agreement between the parties or as may be specified by the law for the time being in force, and in the absence of both as may be prescribed by the central government in consultation with the professional body associations. The law explaining the definition of reasonable security practice is yet to be laid down and the central government is yet to frame its rules thereon. Perhaps we can take guidance from certain foreign laws on data protections and standards laid down in the European Union or by organizations such as OECD in protection of sensitive personal data. It is a challenge for the central government to prescribe in consultation with the professional bodies the information that fall within the meaning of sensitive personal data or information. Critique on the amended section 43 of the IT Act. The Amended Act provides a distinction between contravention and offence by introduction of the element of mens rea for an offence, section 43 for contravention and section 66 of the Act for the offences. It is pertinent to note that no ceiling limit for the compensation is prescribed under section 43 of the Amendment Act 2008, which was 1 crore rupees in the IT Act. The removal of the ceiling limit can be misused or abused, particularly seen in instances where company files frivolous claims against its ex-employees who may have joined a competitor firm without breaching its employment contract. In my opinion, one major diversion from the earlier IT Act is the fact that the amended section 43 has the insertion of section 43 subclause 1 and j in the amended act, which may require an element of mens rea with actus reus. Particularly, section 43 subclause j requires presence of mens rea, and the same acts mentioned in section 43 when committed dishonestly or fraudulently are punishable under amended section 66. The intent behind this change is not only punish the offender for its criminal act, but also to compensate the victim with pecuniary damages for loss incurred due to the acts of the offender. In my view, this is a positive change, since a ceiling or a compensation that may be awarded in section 43 rendered at risk those companies that invest huge amount of money in their research and development, and an employee simply steals away the valuable information or resource by electronic means without due remedy or award of compensable damages. The relevant provision is as under any provision without the permission of the owner or any other person who is in charge of a computer system or network, steal, causes, destroys or alter or causes any person to steal, conceal, destroy any computer source, code used for a computer resource with an intention to cause damage, he shall be liable to pay damages by way of compensation to the person so affected. The intention of the amended act is to introduce the element of intention in this clause of the section, and this mens rea element also find its root in section 66, where a person will be sentenced if he does the same act dishonestly or fraudulently within the meaning of Indian Penal Code, there is with the intention to defraud or cause wrongful loss. Intention to cause damage in section 43 subclause j can be said to also include intention to cause wrongful loss. First, see, stealing cannot be done without the mens rea in the place, and therefore, this act should fall under section 66 and not 43, in case section 43 is to cover only acts done inadvertently or by negligence. This certainly cannot be the intention objective of the amendment. Hence, a clarification on this point is necessary. Yes, the very important definitions has been added. The two very important definitions are added to the IT Act through the IT Amendment Act 2008 is section 2 subclause HA, which means communication device, is section 2W, it means intermediary. Although cell phones and other devices used to communicate would fall under the definitions of the computer in the IT Act, this amendment removes any ambiguity and brings within the ambit of the Act all communication devices, cell phones, iPods or other devices used to communicate, send or transmit any text, video, audio, image. Definition of intermediary simply clarifies the categories of service providers that come within its definition. That includes telecom service provider, network service provider, internet service provider, web hosting service providers, search engines, online payment site, online auction site, online marketplaces and cyber cafe. legal validity of electronic document, and re-emphasized the two new sections, section 7A and 10A in the Amended Act, reinforce the equivalence of the paper based document to electronic document. Section 7A in the Amended Act makes audit of electronic documents also necessary wherever paper based documents are required to be audited by the law. Section 10A confers legal validity and enforceability on contracts formed through electronic means. These provisions are inserted to clarify and strengthen the legal principle in section 4 of the IT Act 2000 that electronic documents are captured with the electronic documents and e-contracts are legally recognized and acceptable in law. This will facilitate the growth of e-commerce activity on the internet and build netizens' confidence. The role of the adjudicating officers under the Amended Act. The adjudicating officer's power under the Amended Act in section 46 subclause 1A is limited to decide claims where claim for injury or damage does not exceed 5 crores. Beyond 5 crores, the jurisdiction shall now vest with the competent court. This has introduced another form for the adjudication of the cyber contraventions. The word competent court also needs to be clearly defined as per section 46 subclause 2. The quantum of compensation that may be awarded is left to the discretion of adjudicating officer. This leaves a wide room for subjectivity, and quantum should be decided as far as possible objectively, keeping in view the parameters of amount of unfair advantage, gained amount of loss caused to a person wherever quantifiable, and repetitive nature of default, the information technology, qualification and experience of adjudicating officers, and manner of holding inquiry rules 2003 lay down the scope and manner of holding inquiry, including reliance on the documentary and other evidence gathered in the investigations. The rule also provides for compounding a contravention and describe factors that determines quantum of compensation or penalty. In the IT Act 2000, the office of adjudicating officer had the power of the civil court, and all proceedings before it are deemed to be judicial proceedings. A new change is incorporated in section 46 subclause 5, whereby the adjudicating officers have been conferred with the powers of execution of the order passed by it, including order of attachment and sale of property, arrest and detention of the accused, and appointment of receiver. This empowers the officers of the adjudicating officer and extends greater enforceability and effectiveness of its order. New cybercrimes as offences under the Amended Act. Many cybercrimes for which no express provision existed in the IT Act 2000 now stands included by the IT Amendment Act 2008. Sending of offensive or false messages has been inserted in section 66A, receiving a stolen computer resource 1666B, identity theft 66C, cheating by personating 66D, and violation of privacy in section 66E. A new offence of cyber terrorism is added in section 66F, which prescribes punishment that may extend to the imprisonment for life. Section 66F covers any act committed with intent to threat unity, integrity, security or sovereignty of India or cause terror by causing DOS attacks, introduction of computer containment, unauthorized access to the computer resource, stealing of sensitive information, any information likely to cause injury to the interest of the sovereignty or integrity of India, the security friendly relations with the other states, public order, decency, morality, or in relation to the contempt of court, defamation or incitement to an offence, or to the advantage of any foreign nation, group of individuals or otherwise for other offences mentioned in section 66. Punishment prescribed is generally up to 3 years and fine of 2 lakh rupees has been prescribed, and these offences are cognizable and bailable. This will not prove to play a deterrent factor for the cyber criminals. Further, as per new section 84B, abetment to commit an offence is made punishable with the punishment provided for the offence under the Act, and new section 84C makes attempt to commit an offence also a punishable offence with the imprisonment for a term which may extend to on behalf of the longest term of imprisonment provided further for that offence. In certain offences such as hacking, section 66, punishment is enhanced for 3 years and imprisonment and fine of 2 lakh rupees to fine of rupees 5 lakh. In section 67, for publishing obscene information, imprisonment term has been reduced from 5 years to 3 years and 5 years of subsequent offences instead of earlier 10 years, and fine has been increased from 1 lakh to 5 lakh rupees. Section 67A adds an offence of publishing material containing sexually explicit conduct punishable with the imprisonment for a term that may extend to 5 years with fine up to 10 lakh rupees. This provision was essentially to curb MMS attacks and video voyeurism. Section 67B punishes offences of child pornography, child sexually explicit act or conduct with imprisonment on first conviction for a term up to 5 years and fine up to 10 lakh rupees. This is a positive change as it makes even browsing and collecting of child pornography a punishable offence. Punishment for disclosure of information in the breach of lawful contract under section 72 is increased from 2 years to 5 years and fine from 1 lakh to 5 lakh rupees for the both. This will deter the commission of such crime. By virtue of section 84B, person who abets a cybercrime will be punished within punishment provided for that offence under this act. This provision will play a deterrent role and prevent commission of conspiracy linked cybercrimes. Also, punishment for attempt to commit offences is given under section 84C, which will be punishable with 1/2 of the term of the imprisonment prescribed for that offence or such fine as provided as both. Section 67C to play significant role in cyber prosecution. Section 67C brings a very significant change in the IT Act 2000. According to this section, intermediaries shall be bound to preserve and retain such information as may be prescribed by the central government and for such duration and format as it may national seminar on enforcement of cyber law. Any intermediary that contravenes this provision intentionally or knowingly shall be liable on conviction for the imprisonment for a term not exceeding 2 years or fine not exceeding 1 lakh rupees or both. Many cybercrime cases cannot be solved due to the lack of evidence, and in many cases this is due to the fact that ISP failed to preserve the record pertaining to the relevant time. This provision is very helpful in the collection of evidence that can be proved indispensable in cyber crime cases. Section 69, power of the controller to intercept. Amended section 69 that deals with the power of the controller to intercept information being transmitted through a computer resource when necessary in the national interest is amended by section 69. In fact, the powers vest now with the central government or the state government that empowers it to appoint for reason in writing any agency to intercept, monitor, decrypt any information generated, transmitted, received or stored in any computer resource. This power is to be exercised under great caution and only when it is satisfied that it is necessary or expedient to do so in the interest of sovereignty or integrity of India, defense of India, security of the state, friendly relation with foreign state, or public orders by preventing incitement to the commission of any cognizable offence relating to above or for the investigation of any offence. The procedure and safeguards to exercise these powers are laid down by the Information Technology Procedures and Safeguards for the Interception, Monitoring and Decryption of Information Rules 2009. The subscriber or intermediary that fails to extend cooperation in this respect is punishable offence with a term which may extend to 7 years and imposition of fine. The element of fine did not exist in erstwhile in section 69. The said rules provide ample safeguards to ensure that power in this section is diligently exercised with due authorization, procedures complied with and not abused by any agency, intermediary, including maintaining confidentiality and rules for maintaining or destruction of such records. Now, we will discuss the combined effect of section 77 and 77b. By virtue of section 77, compounding of an offences other than offences for which imprisonment for life or punishment for a term exceeding has been provided has been made possible. Section 77b makes offences punishable with imprisonment of 3 years and above as a cognizable and offence punishable with 3 years of punishment as bailable. Since the majority of the cyber crimes defined under the Amended IT Act are punishable with imprisonment for 3 years, the net effect of all the amendment is that majority of these cyber crimes are bailable. This means that the moment of cyber criminal is arrested by the police, barring a few offences in almost all other cyber crimes, he has to be released on bail as a matter of right by the police. A cyber criminal once released on a bail will immediately attempt at destroying or deleting all the electronic traces and traits of his having committed any cyber crime. This makes the task of law enforcement agencies extremely challenging. In concluding remarks, I must say that IT Amendment Act 2008 from an overall perspective has introduced remarkable provisions and amendments that will facilitate the effective enforcement of cyber law in India. India is now technologically neutral with electronic signature replacing the requirement of digital signature. The importance of data protection in today's information technology age cannot be undermined and it finds place in section 43, 43A, 66 and 72. In this era of convergence, the definition of a communication device intermediary has been rightly inserted, revisited and validity of e-contract is reinforced by insertion of section 10A of this particular act. Thank you viewers for watching this program.